Okay, Pops, and legal reform on Facebook. This was a video I ran across about massive court corruption. Now, this is pretty casual. This actually happens in every court across the U.S. This isn't a criminal court. Uh, this kid suing the public defender's office for literally throwing his case. And there's a lot of other stuff that he doesn't know that they should be telling him. Okay, so as far as his attorneys go, in the preamble, okay, this is from Utah. You can download the PDF. Preamble, lawyer's responsibilities. Okay, lawyer is a representative of clients, an officer of the legal system, and a public citizen having special responsibilities for the quality of justice. Every lawyer is responsible to observe the law and the rules of professional conduct, shall take the lawyer's oath upon licensure, and shall be subject to the rules of lawyer discipline and disability lawyer's oath. I do solemnly swear I will support, obey, and defend the Constitution of the United States and the Constitution of Utah, and I will discharge those duties of a lawyer and counselor at law as an officer of the court of the states with honesty, fidelity, professionalism, and civility, and that I will faithfully observe the rules of professional conduct and standards of professionalism and civility promulgated by the Supreme Court of the state of Utah. As a representative of clients, the lawyer shall perform various functions. As advisor, the lawyer shall provide a client with informed understanding of the client's legal rights and obligations and explain their practical implications. As an advocate, a lawyer zealously asserts the client's position under the rules of the advisory system. As a negotiator, a lawyer seeks as a result advantageous to the client but consistent with the requirements of honest dealings with others. As an evaluator, a lawyer acts with examining a client's legal affairs and reporting about them to the client or others. A lawyer's representation of a client, including representation by appointment, does not constitute an endorsement of the client's political, economical, social, or moral activities. In addition to these representative functions, a lawyer may serve as a third-party neutral. Well, anyways, there's a whole lot here that he's supposed to explain to his client. That falls under informed consent. Now, how is he getting informed consent if he doesn't even know the rules of professional conduct exist? Okay, that's just the preamble. Okay, rules of professional conduct, advocate. So we're going to get into that. Lawyer relationship. Must be competent, diligent, and he can't be competent or diligent if he lacks communication. So if he lacks communication, which is giving his client informed consent, and I just read the preamble to you, so he's not doing that, confidentiality of information, the public defender and the state's attorney judge already decided before this kid even walked into the room to have a warrant for his arrest. I'm going to play the video for you after I go over a few of these things. Special conflict of interest, safekeeping property, that's for conservatorship, duties to a prospective client, violation of that rule. Maintaining the integrity of the profession, failure, that's a failure. As an advisor representing a client, a lawyer shall exercise independent professional judgment and render candid advice. In rendering advice, the lawyer may refer not only to law but other considerations such as moral, economic, social, and political factors that may be relevant to the client's situation. The client scope of advice. Now, this is for the lawyer telling him how he's supposed to do this. The client is entitled to straightforward advice expressing the lawyer's honest assessment. Legal advice often involves unpleasant facts and alternatives which the client may be disinclined to confront. Okay, so this is basically telling you what the lawyer is supposed, how he's supposed to play this out as an advisor. Okay, as I mentioned, maintaining the integrity of the profession. Misconduct, not abiding by any of the rules of professional conduct is misconduct. Reporting misconduct is mandatory. So not only was this lawyer supposed to report himself, but the state's attorney for not reporting them, reporting the state's attorney uh, for failure to abide by special rules of the prosecutor, supposed to report the judge for failure to report them for misconduct. Okay, so let's go here. Like I said, reporting misconduct, it'll tell you it's mandatory. Okay, a lawyer who knows that another lawyer has committed a violation of the rules of professional conduct to raise substantial questions as a lawyer's honesty, trustworthiness, fitness as a lawyer in other respects shall inform the appropriate professional authority. A lawyer who knows that a judge has committed a violation of the applicable rules of judicial conduct that raises substantial question as a judge's fitness for office shall inform the appropriate authority. This rule does not require disclosure of information otherwise protected by Rule 1.6 or the information gained by a lawyer while participating in approved lawyers assistance program. Okay, so comments. Now, this is a warning to telling the lawyers how this is supposed to work out. Self-regulation of the legal profession requires the members of the profession initiate an investigation when they know a violation of rules of professional conduct. Lawyers have a similar obligation with respect to judicial misconduct, an opportunity, an apparently isolated violation, and none of these are isolated because there are multiple counts of violations of the rules of professional conduct and the code of judicial conduct. An apparently isolated violation may indicate a pattern of misconduct that only disciplinary investigation can uncover. Reporting a violation is especially important where the victim is unlikely to discover the offense. Now, this kid doesn't know any of this, which falls in the realm of informed consent. Okay, so there's a whole lot this kid's got to go over. Okay, this is the Utah Code of Judicial Conduct. Okay, Canon 1. The judge shall uphold and promote the independence, integrity, and impartiality of the judiciary and shall avoid impropriety and the appearance of impropriety. Rule 1.1, compliance with the law, rule which they didn't. The judge is supposed to enforce the rules of professional conduct, which they didn't, and did not report misconduct, which reporting misconduct is mandatory. Rule 1.2, promoting confidence in the judiciary, which was quite the opposite, appearance of impropriety, integrity of the judiciary. Rule 1.3, avoiding abuse of prestige of judicial office. Canon 2, a judge shall perform duties of judicial office impartially, competently, and diligently. That's a big violation there. Annotations to Canon 2, giving precedence to the duties of judicial impartiality and fairness, which you'll see that there wasn't any. Bias, prejudice, and harassment, which that's all that was in this case. It was bias, prejudice, and all they did was harass the kid. If he didn't take what they were throwing at him, when he walked into court for the very first time, they said, "Here, sign this and you can go." He said, "No." Maybe he asked for a probable cause hearing. Maybe he said he wanted to take this to court because what he was arrested for didn't happen. Judges and the lawyers don't like that. They don't like coming out there. The judge does not like coming out there into the court. If the judge don't have no cases, he or she is paid to sit in the back all damn day. So they don't like coming out there. External influence on the judicial conduct. Okay, rule 2.5, competence, diligence, and cooperation. Remember, anytime anything goes through court, the judge must show competence, show diligence, meaning that case is supposed to get over quick, fast, and in a hurry. So if the kid asks for a probable cause hearing, there's no probable cause, then it's supposed to be disposed of on the spot, in and out in one day. And cooperation. Cooperation means with you, the client. Ensuring a right to be heard. The kid was asking questions and the judge didn't like it, but he's supposed to let this kid say his thing. And this kid, if he had known all this, he could have sided with them as they would have vacated the court. Responsibilities to decide, decorum, demeanor, and communications with jurors. Uh, okay. Judicial statements on pending and impending cases, disqualification. Okay. Responding to judicial and lawyer misconduct. Okay. Responding to judicial and lawyer misconduct. That's the way, that's the reason the judge recused herself from the case, but she didn't hit the lawyers for misconduct. It's telling you right there, it's supposed to. Cooperation with disciplinary authorities. That would mean filing against everybody, filing against each other and themselves. So there was no cooperation with the disciplinary authorities. Canon 3, the judge shall conduct a judge's extrajudicial activities to minimize the risk of conflict with obligations of judicial office. Uh, Extrajudicial activities in general, appearance of impropriety, casting doubt on impartiality, exploiting the judicial position, interference with impartiality, interference with performance of judicial duties. A complete failure on that, Judge. Appearance before government bodies, with government officials, affiliation with disciplinary organizations. Candidate for judge or candidate for judicial office will not engage political campaign or activity. That's in every state, and that's even for the federal. Not supposed to get involved in politics. So canon 1, like I said, a judge shall uphold and promote the independence, integrity, and impartiality of the judiciary, shall avoid impropriety and the appearance of impropriety. Compliance with the law. The judge may execute an agreement with the private prohibition provider as long as the judge's legal advisor determines the agreement is legally permissible. Legally permissible. Anything that went on in that courtroom was not legally permissible. Trial court judge must follow an appellate court directive, even if it appears that directive conflicts with statutes or rules. Promoting confidence in the judiciary. One, appearance of impropriety. There's a lot of stuff this judge didn't do that the judge was supposed to do. But see, that happens in every court. So if you don't take your own bitch book, the rules of professional conduct and the code of judicial conduct, what you the same thing that happened to you that happened to this kid. Don't forget all that other stuff I told you about. Holding them to the oath they took. Lawyers, judges take an oath to uphold the Constitution, defend it. Particularly in court, your right to due process. It goes on and on and on. A judge shall perform duties of judicial officer partially, competently, and diligently. 2.1, giving precedence to the duties of judicial office. Impartiality and fairness. Judge may not refer parties to specific mediator. Appearance undermine the judge's impartiality if the mediator cases come before the judge. Uh, 2.3, you don't even have, there's no explanation of that. Bias, prejudice, and harassment. Judge can't do that, but the judge was biased, prejudiced, and did not harass this kid because the kid didn't sign that piece of paper when he first came into court like the public defender wanted. The statistics are out there if you check, but you have to really check. But the public defender office has a higher rate of conviction than the state's attorney's office. Actually, a state's attorney's office, a lot of their convictions are because the public defender does this to people. This is a constant in every court across the United States. 2.5, competence, diligence, cooperation. Ensuring the right to be heard. Although a judge may often ask questions in the course of the trial, a judge commits error when a judge questions the defendant extensively about weak aspects of the defendant's defense. Responsibilities to decide, decorum, demeanor, and communication with jurors. Judicial statements on pending and impending cases. Disqualification, affiliation with a lawyer, judge previously worked with an attorney in the legal defender's office may not hear a case in which the legal defender attorney appears in representation of the matter which undertaken at the time when the judge was employed by the legal defender. So that would have to be looked into, but I'm quite sure the judge was at one time or another. A lot of stuff explaining what a judge should do and shouldn't do. Supervisor duties. Responding to judicial and lawyer misconduct. The judge didn't do that. Cooperation with disciplinary authorities. The judge didn't report the lawyers or herself. That is a failure to comply with Rule 2.16. Canon 3, a judge shall conduct a judge's extrajudicial activities, minimize the risk of conflict with obligations of judicial office. So there's a lot this kid needs to go over, but nobody's going to tell him. Because if the judge and the lawyers, they report each other, that goes to the state Supreme Court, and they're going to say, hey, well, you know, if you do something, you tell on us, we'll tell on everybody does this. All lawyers and all judges violate the rules and the codes, and they're not going to tell on each other. They're definitely not going to tell this kid what they did to him. Now, informed consent would consist of knowing the rules and the codes exist and what you can do about it. Okay, so let's go over here. This is the Utah courts. The Utah judiciary is committed to the open, fair, and efficient administration of justice under law. Find important information on what to do about a case where to find and help, alerts, and information due impact. Oh, okay, never mind. Let's go here. Judicial Conduct Commission. A strong, independent Judicial Conduct Commission is critical to a successful judiciary. Judicial Conduct Commission is established by the Utah Constitution as an independent agency to investigate complaints alleging the unethical conduct of judges to the order of appropriate sanctions. The Judicial Conduct Commission is separate and independent from the Utah court system. The commission is comprised of 4 legislators to each the Utah State Senate, House of Representatives, 3 members of the public, 2 attorneys, and 2 judges. The commission does not review a judge's decisions for correctness that is left to the Supreme Court and the courts of appeals. The commission determines whether the judge conduct violates code. Of Judicial Conduct Commission may reprimand, censure, or suspend or remove a judge from office. Any person may file a complaint with the Judicial Conduct Commission. The commission, its staff, investigates the facts alleged in the complaint, and if warranted, the commission holds a hearing. The hearings and records of the Conduct Commission are private until the case is filed with the Supreme Court, which reviews all the commission orders. The commission is located at 1385 South State Street, Suite 143, Salt Lake City, Utah. 84115, telephone number 801-468-0021. Website www.jcc.utah.gov. See, and here's where the kid got it filed in court. Utah Court of Appeals. Filed November 19th, 2020. I doubt they heard about it by now. The District Court of West Jordan Department, North Hinsdale, L. Douglas Hogan, Christian Foster Judge. Now, this judge here is supposed to report the judge and the lawyers in that case to the Judicial Inquiry Board. And, once he cites the judge for failure to comply with the Code of Judicial Conduct, and since it's mandatory to report lawyers for the violations of the rules of professional conduct, so he'll cite the judge for that. So it'll take a domino effect. It'll take down the judge and the lawyers filing for violations of Code of Judicial Conduct. So, but these judges here, they aren't going to do it. Because if they file against that judge and those lawyers, they're going to say, well, hey, you do it too. You do it too. So they can turn around and file on the appellate court judges to the Supreme Court. And then if the Supreme Court goes for it, well, the appellate court judge is going to say, hey, well, you do it too. And then it's going to bounce up to the U.S. Supreme Court, and they do it too. Nobody reports anybody for violations of the Code of Judicial Conduct or the rules of professional conduct. Okay, let's take a look what's going on here. Those are the public defenders.
Good morning, Your Honor. Pretty good.
The kid's waiting outside them doors right behind her.
And Your Honor, Mr. Morris is here today to ready on his examination. B2, state of Utah versus Sanchez. You don't expect me? You're not expecting him?
Well, I always expected, although last time he was not here, and it was only after my secretary called him that he remembered to come. So
Was that bench warrant 15,000 cash and that's body forfeiture?
take your that's what might be excused.
We're going to take him into custody. Hey, Steve? Utah versus Bradford.
That's her talking to him right now. Right over there. Malicious prosecution. State's attorney. Special rules of prosecutor. Not to prosecute, but to see the justice is served.
Was that one we already called and issued a warrant because he's always late or not showing up? And we're going to execute the warrant. So we'll see if he comes in here. Calls the There's a public call. This is a traffic. He wants it executed. He's not going to come say they wanted it. He's going to execute the warrant. But he's out there. Probably his attorney or something.
And the judge was laughing.
He's good at what he does. He doesn't ask until he's between him and the door.
Take him into custody.
Sometime after 9 o'clock. But this isn't a social event. So maybe we should call it so that we can document what time he came in. State of Utah versus Sanchez. I just want to make sure we could see you before you go back. Your case was already called this morning. We just saw you arrive about 10 minutes ago, which would have been a quarter to 11. Well, you did not come to our courtroom until a quarter to 11. This is the third time you have either missed or been hours late. So we issued a bench warrant for you. We're going to execute it at this time. We told you last time if you were late, you're going to go into custody. So
I spoke with Heather at 9:17. I think I was here earlier.
Your Honor, I saw the defendant here. When I first saw him, I recognized him. I looked at the clock. It was 9:38 is when I saw him here. I'll note for the record that his attorney is the one that called the case, and we've had this conversation at least 3 times.
Could I just know what time the warrant was issued? What time did my attorney leave?
That, you can ask your attorney about that, but we didn't issue it until after 9, and you're here way after that.
Look at that, big joke to everybody in the courtroom. Okay, no one can state qualified immunities because it says here in the United States immunity is illegal. Hold on. Is a legal principle that grants government officials performing discretionary optional functions immunity from civil suits unless the plaintiff shows that the official violated clearly established statutory or constitutional rights in which a reasonable person would have known. It is a form of sovereign immunity. Hold on. It is a form of sovereign immunity less strict than absolute immunity, which is intended to protect officials who make reasonable but mistaken judgments about open legal questions, extending to all officials but plainly incompetent or those who knowingly violate the law. Qualified immunity applies only to government officials in civil litigations and does not protect the government itself from suits arising from official actions. The U.S. Supreme Court first introduced the qualified immunity doctrine in Pearson versus Ray, 1967, a case litigated during the height of the civil rights movement. It is stated to have been originally introduced with the rationale of protecting law enforcement officials from frivolous lawsuits and financial liability in cases where they acted in good faith in unclear legal situations. Nobody has a right to qualified immunity here because everybody knowingly and willingly and wantingly disregarded the code of judicial conduct and the rules of professional conduct. In both, reporting misconduct is mandatory. Man, I feel bad for that kid, but it happens to everybody, especially in criminal court. You got a public defender, the first thing they're going to want you to do is sign a piece of paper and leave. And if you do that, you're going to leave with a felony. I stop people from doing that plenty of times. And they always got threatened. Well, if you don't sign this paper, the judge is going to get mad and the state's attorney is going to up charges. I told you people that's malicious prosecution. They can't do that. You're in here for one thing. They say, if you don't sign this paper, we're going to charge you with something more. And then there's no probable cause hearing. And expediting litigation requires that dash cam and the footage from the police station, but you see that the police said they didn't have it. And the judge legally can't go by the cop's word. Hearsay testimony cannot stand in a court of law. That's no grounds for a conviction. This is legal reform. Legal Reform on Facebook. Pop, signing off.